Started. Good morning, everybody. Welcome to the, well, it's actually the International Committee and also the tax section program on imminent changes to international tax regime for corporations with cross-border activities. I'll introduce the program in a moment, but in the meanwhile, I have a couple of housekeeping announcements. You'll receive your MCLE certificate shortly after the program. Your certificate will also be stored in BHBA Plus, our members only community. Please take a moment to complete the survey that is included with your certificate. The program will be available in a couple of days in BHBA On Demand, BHBA's newest member benefit, presented by Lawyers Mutual Insurance Company. The tax section is sponsored by Hochman Salkin, Tasha Perez PC. We appreciate their constant support. They've been supporters for a long time of the tax section. The Hochman Salkin Tasha Perez PC advantage is experience, an eye for innovation, and a genuine dedication to clients, their families, and their businesses. In addition to their national practice in civil tax and criminal tax controversies and related litigation in federal and state courts, the firm is also active and successful in handling non-tax matters such as business and estate planning for high net worth individuals and closely held businesses, together with white collar defense and commercial disputes. I'm Michelle Weiss. I'm the chair of the tax section. I just want to welcome you to our program with Bryan Kelly of Wilkie Farr and Gallagher, William Norman of Norman and Zach, and coming all the way from Germany, Dr. Tim Zinowsky from Flick, Gocke, and Schaumburg in Bonn, Germany. And if you have questions, please put them in the Q&A function and they will be handled at the end of the program. Bill, take us away.
Okay. Thank you. Let's get the first agenda slides up there if we can. There we go. All right, this program has been several months in planning. There's never seems to be quite the right time to give an update on what's happening with the this massive change in or proposed imminent change in international tax regime. It's the most major change since 1921. So it is a big deal to the extent it applies to a particular taxpayer. Let me just briefly go over the agenda and then turn it over to Tim to talk about the first items in our agenda. Next slide, please. The changes in international tax regime are put into two pillars, if you will. Just topics. The first one, pillar one, deals with tax jurisdiction without physical presence, and we'll talk about what that is, and come back after we talk a little bit about pillar two to deal with the interaction between the pillars and the U.S. foreign tax credit regulations and various digital services taxes that are being adopted by various foreign countries. We'll talk about pillar two, what its basic elements, and then the EU proposals, the 5-nation pledge. Some countries are already kind of out of the gate on these particular provisions. Germany has some proposals that Tim will talk about. And then I will talk about the relationship, if you will, of the pillar two and some changes in the U.S. law. New minimum tax on certain large corporations, and also the relationship to our guild regime. So with that, Tim, take it away from Germany.
All right, I'm going to share my screen. If I can. Yes, I can. Okay, I hope you can see that. Do you see the slides?
Bigger or not, I'm not sure. There you go.
Now you should see them, right?
Very good.
Perfect. So I'm gonna tell you a little bit about the key elements of pillar one and pillar two. Of course, starting with pillar one. Of course, 90 minutes are not enough to talk about the various details of these rules. However, I want to give you a brief overview on the why, when, and the basic mechanics of the rules. So maybe a few words on the background. So the starting point of all this work on Pillar 1 and Pillar 2 has been the work of the OECD on BEPS Action Item 1, dealing with the challenges that result from the digital economy, things like transparency, data protection, and of course the market dominating position of a few very big players. So if we look at the 20 biggest so-called internet companies of the world, so like Amazon, Google, Apple, Alibaba, the 20 largest firms in that sector are resident in the US and China. And the fundamental challenge with regard to the taxation of these multinationals who have a digital business model is that the traditional transfer pricing and the traditional profit allocation rules do not do a very good job in allocating the income among countries in a way that is perceived to be fair from the perspective of the market jurisdictions. Market jurisdictions are the countries where the consumers or the customers of Netflix, Google, Amazon, and so on, where the customers are located. So if you think especially about the big economies that provide for good infrastructure, especially good digital infrastructure, and a lot of users, think of Germany and France, for example, they think our share in the profit of these entities that we are entitled to tax is not really fair. So that's why they called for work on new taxation rights. And until summer 2016, something around that edge, the OECD did the follow-up work on BEPS Action Item only among its members, so the 38 states. And then they set up a working group that is called the Inclusive Framework. And the Inclusive Framework is all the OECD states plus many other countries, including developing countries. I think today, the Inclusive Framework comprises 141 states. And this Inclusive Framework issued model rules or action points on two pillars, Pillar 1 and Pillar 2. And the latest publications on the respective rules have been published in December of last year for Pillar 2, and this summer a public consultation paper on Pillar 1. So to just tell in a nutshell what Pillar 1 and Pillar 2 are about, if you look at headlines of big German newspapers or technical journals, they say this is BEPS 2.0, and this is a new world tax regime. So what is this new world tax regime about? Pillar 1, if you look at Pillar 1 from a conceptual perspective, Pillar 1 is actually not intended to increase the global tax burden of multinationals, but shall only result in a different allocation of these profits, of these group profits among the countries in a way that is perceived to be fairer than the current allocation. Pillar 2 actually wants to increase the global tax burden of multinationals by making sure that every single dollar that is earned in any country is at least subject to a tax of 15%. So Pillar 2 introduces a global minimum tax of 15%. And interestingly, looking at the background, so where we're coming from and the intention, most interestingly, both pillars do not only apply to digital business models, but to any kind of business. So let's look at objective solution and timeline. As I said, the objective is to get to a fairer allocation of profits within multinational groups. And I mean, for the US, as an example, if you look at typical setups, what we typically see is that US multinationals act in Europe via routine entities. So they set up contract manufacturers and they set up limited risk distributors. And all these entities then earn just a routine margin, cost plus 5% for manufacturing, or a fixed EBIT margin between 3 and 6% for distribution. And all the residual profits goes up to the US. And from there, it is maybe shifted to Cayman Islands via profit sharing agreements, stuff like that. This is not the second part is not the focus of pillar 1, it's the focus of pillar 2. But the first part, so that the residual profit goes up to the US, this is in the focus of pillar 1. And to actually get to a fairer allocation of these profits, the solution of pillar 2 provides for an additional taxation right for the market jurisdictions. So for all the subsidiaries of multinational groups. And this additional taxation right is called Amount A. And it's a kind of consideration for the subsidiaries' contribution in the group's IP value or the profits. Looking at the timeline, this is of course super relevant. This additional taxation right shall be implemented in course of a multilateral instrument, and the signing ceremony shall be held in the first half of 2023, which is super early, right? I mean, looking at the calendar, we already have October. So I don't think it's going to happen, but that's the plan. And the new rules shall enter into force in course of 2024. Again, that's a pretty tight game plan. However, what is relevant? 2 or 3 weeks ago, Germany, France, Spain, Italy, and the Netherlands announced that they definitely want to stick to these plans. They definitely want to stick to that timeline, and they are going to implement these rules no matter what the US are saying and no matter what, for example, Hungary is saying, because that's the country that is against these rules currently in the EU. Okay, then jumping to the mechanics of pillar 1. If we look at the scope, who's in the scope of these rules? In the scope of pillar 1 are all groups that fulfill the requirements of the revenue test and the profitability test. The revenue test is fulfilled if the global consolidated group revenue, based on your group financial statements, exceeds the amount of 20 billion euro. And the profitability test is fulfilled if your pre-tax profit margin exceeds 10% in the year under review. This is a little bit simplified. There are some, it's a little bit more complicated, but I think if you leave this webinar and you remember that the revenue threshold is 20 billion and the profit margin, the threshold is higher than 10%, then that's okay, right? There are some exceptions with regard to financial services activities or extractive activities, but I think there's still a lot of work to be done on the details of these exceptions. So once you know you're a covered group, your income is allocated to the respective jurisdictions you're active in, following 2 amounts. So for every jurisdiction, you have to, for every jurisdiction, an amount A and an amount B will be subject to tax. It's a little bit weird. I would have done it the other way around. So amount B is the so-called routine profit. It's the profit that is taxable if you apply today's traditional transfer pricing rules. I added a question mark in brackets if you look at the amount B box, because there's going to be a public consultation paper on the calculation of amount B, and if these really were only the traditional rules, there would be no need for a public consultation paper. So let's see what will be in there. Maybe this is a little bit different. So, but that's the first part. Amount B, the routine profit, and then the additional taxation right is described by amount A. And let's jump into the calculation and the determination whether someone is entitled to tax that amount A. In the first step, every jurisdiction has to determine, am I entitled to tax amount A? In the second step, you need to calculate amount A. And then the third step, you should make sure that there's an exemption for that amount at a higher level in the chain, right? To avoid double taxation. It's not finally clear which level actually has to exempt amount A from its tax base, whether it's a Lux holding company of a German entity in a multinational group, or whether it's the ultimate parent entity of the group. So there will be further guidance on that. So to determine whether I'm actually entitled to tax amount A, I have to look at the so-called special purpose nexus rules and the revenue sourcing rules. The special purpose nexus rules say that every market jurisdiction that derives third-party revenue exceeding 1 million euro is entitled to tax amount A. So if there's a German entity of Netflix generating German revenue exceeding 1 million, then Germany would be entitled to tax amount A for that entity. Of course, there's always a question, what is German revenue or what is German sourced revenue? And there the revenue sourcing rules kick in. These are complex rules on the determination of the origin of income. And as a rule of thumb, it's the location of the customer or the recipient of a service or transaction. So if someone types into the Netflix account, hey, I'm resident in Germany, this is most likely going to be German sourced income. So once Germany knows, hey, we're entitled to tax amount A, the question is, how do I determine amount A? And for that purpose, you have to look at the whole profit of the group and split it into a portion that remains with the home country, here, for example, the US, so the home country of the ultimate parent entity, and the amount that is allocated to other jurisdictions under the Pillar 1 rules. And this aggregated amount A is 25% of the excess profit of the group. And the calculation of the excess profit might remind you of the Gocke rules. It's the adjusted profit before tax, adjusted because there are special calculation mechanisms for Pillar 1, minus 10% of the group revenue, which is a kind of routine return, right? So 25% of the excess profit of a group are the aggregated amount A, and then the allocation of each entitled country's taxation right is determined by simply multiplying the respective country's share in group's revenue with the aggregated amount A. So if Germany provides for 30% of the group's revenue, then 30% of the aggregated amount A would be taxed in Germany. Talking about open issues and challenges, there's a lot of stuff to do. I mean, looking at the practical calculation of these rules, there will be a lot of things to be said about, especially the revenue sourcing rules. So how can I, as a service provider, make sure that my customers are saying the truth? So if I register a Netflix account today and say, hey, I'm a 14-year-old Chinese girl, who could prove that I'm not in China? So, and can the taxpayer rely on that information provided by the customer? Can he be held liable if the information was wrong? These are a lot of things that need to be clarified. And just to give you a broad idea of how complex these rules are. I mean, if you look at the public consultation documents and you leave away all the cover pages, table of contents, summary, and so on, these are net 84 pages. 84 pages, and from these 84 pages, 11 pages make the core rules, plus 8 pages make the definitions for the core rules. And the remaining 65 pages provide for schedules, calculation, technical rules on specialties, and so on. And of these remaining 65 pages, 28 pages are definitions. So of these whole 84 pages, there are 36 pages of definitions. And as we know, every definition has some legal uncertainty if it's applied to the actual practical case. So there will be a lot of things going on, and there will be a lot of things to be discussed in the future on Pillar 1. I think that's it for Pillar 1 for the moment. And before we go on to Pillar 2, I think Bryan or Bill, you want to jump in, right?
Yeah, I'll jump in. If you'll unshare your slides, I'll take a crack at sharing mine.
And Bryan, I have yours ready to go if you can't, or if you're unable to share yours.
Thank you. Okay, is that visible to everybody?
Good.
Okay. Yeah, thanks for that, Tim. Why don't we, so toggling over to talk about the U.S. foreign tax credit rules, because this is an area where there's been some activity, and Bill will talk about what has and hasn't happened in the broader context, but we did want to spend a chunk of time talking about the foreign tax credit rules because that's where Treasury has acted, and there's some overlap here with Pillar 1 and related developments. And we'll start off with a quick overview of the key bits of the foreign tax credit rules, and then discuss recent developments both globally and in the U.S. And then finally take a look at what that's translated into in terms of changes to the rules. So let me see. Let's see if I can toggle over. Let's see if we're lost. Seem to have lost the Zoom. Sorry, folks. I don't know if everybody else is still able to see the Zoom screen.
We can still see your Zoom. I mean, we can still see your presentation.
Let me stop the share and try it again. How about now?
We can see it.
Okay, wonderful. Okay. So a quick overview of the U.S. foreign tax credit system. These rules have been around for a long time, and they've evolved considerably over time. And we may be seeing another substantial evolution now. And at a very basic level, for a foreign levy to qualify as a foreign income tax under these rules, it needs to either be a net income tax that's creditable under Code Section 901, or a tax in lieu of a net income tax that's creditable under 903. There are, in some cases, indirect credits available, not the focus of today's discussion. And there are built-in limitations on the ability of taxpayers to use the credits. The 904 limitation is intended to prevent the use of foreign tax credits to offset U.S. source income, and that's, you could see sort of through in the formula there, that's when expressed mathematically is a U.S. taxpayer's U.S. federal income tax multiplied by a fraction, the numerator of which is their foreign source taxable income, and the denominator, which is their worldwide taxable income. And there are other limitations on the usage of tax credits. For instance, our expense deduction rules operate as a limit because the limitation is computed based on taxable income. And there's sort of a complicated set of separate calculation baskets and overall limitation rules. But the focus today really is setting aside some of those limitations on utilization. What is a creditable foreign tax? And how has that changed really over the last year? So let's kind of talk for a moment about what spurred the change. You know, in the wake of the BEPS project and the Pillar 1 and Pillar 2 developments that Tim has discussed, there are a number of countries that have taken unilateral measures, mostly aimed at digital or online transactions, which people are generally referring to as digital service taxes. And there's been a proliferation of these taxes over the last few years, and the count varies depending upon how you measure and which taxes you stick into that bucket. But by some measure, there are now dozens of these taxes that have been either enacted or proposed. And, you know, the commonality is that they work off of what people refer to as destination-based or market-based sourcing principles. They assert taxing jurisdiction based on where somebody's customers or users are, as opposed to where the activities take place. And that's considered by some to be a sharp departure from historic international tax norms, which really focused, typically would source income to the place where the activities occurred. So digital service taxes, very briefly, as I said, common feature is destination-based sourcing principles. Beyond that, they tend to vary pretty widely. They do tend to be gross basis taxes rather than net. And they use varying levels of worldwide and in-country revenue thresholds. The UK enacted some legislation just by way of example, and I believe the thresholds that they use are 500 million pounds global in-scope revenue and 25 million of in-scope revenue derived from customers or users in the UK. But that's all over the place, and there are some taxes, some countries that have enacted taxes that don't even have thresholds. And the taxes vary widely also in terms of what their tax base is, with some, very targeted to online advertising or sort of online marketplace type services like an Amazon type of platform, and others that are drawn much more broadly. And in that environment, there's been some movement in the U.S. regulatory framework, with Treasury issuing proposed regulations in late 2020 and finalizing those without really any directional changes earlier this year in Treasury Decision 9959. And that regulatory package is actually quite extensive and contains a laundry list of changes to various provisions. And we're going to just focus today on the ones that directly impact the determination of when a foreign tax is creditable under 901 or 903. And that's at a real high level. Under the prior rules, in order to be creditable, a foreign levy had to be a tax. And that in and of itself is a term of art, but at a very high level that meant, and still does mean, a compulsory payment that is imposed, a compulsory payment requirement that's imposed under jurisdictions' taxing rules. And the predominant character of that tax had to be that of an income tax in the US sense. And the regulations provided that if that requirement would be met if the tax was likely to reach net gain in normal circumstances that it applied. And the net gain requirement in turn was broken down into a number of sub-requirements and determined to be satisfied if in normal circumstances it would satisfy realization, gross receipts, and cost recovery elements. And those are, I'll unpack those a little bit, but they are what you probably suspect that they are. They're the building blocks of a net income tax. You know, a net income tax has to have a realization concept. It has to be able to, you have to be able to discern when you have had an event that requires you to recognize income. There has to be a tax base, which means you have to be able to know what gross receipts or gross income to include in that cost base, and whether you're entitled to recover attributable costs. And the prior regulations tended to tie these requirements loosely to the US concepts. So in general, a foreign tax would qualify if, based on its predominant character, realization, for example, happened at the same time that realization would happen under the US tax rules, but with some flexibility and some recognition that there could be situations where the timing of realization would differ under a foreign tax rules. So the final regulations eliminated the predominant character concept and made some substantial changes to the gross receipts and cost recovery concepts of the pre-existing rules. And the big picture takeaway from those changes is those are still factual determinations, but the elimination of the predominant character concept and the addition of some more detailed mechanics, for instance, in the context of cost recovery, a list of costs that are considered to be per se significant and subject to exceptions, typically would need to be deductible, such as interest expense and research and experimentation expenditures. At a real high level, although we have little experience with the new rules, probably what this does is eliminate some of the flexibility from those requirements. But what probably the bigger headline there is the addition of an entirely new concept, a nexus concept. And that's referred to in final regulations as the attribution requirement. And it is an imposition of US-based nexus principles on to foreign taxes. That is to say, there's now a fourth hurdle. Even if a foreign tax satisfies the realization, gross receipts, and cost recovery requirements, it's still not a creditable tax in the Section 901 sense unless it also satisfies these nexus rules. I'm going to pass over the next few slides are really just to high level flag some of the key differences between the prior and final regulations on the realization, gross receipts, and cost recovery requirements. But I'm gonna jump us to the attribution requirements because that's where I think we want to spend the most time because it's an entirely new requirement, and it, you know, from what's in the preambles to the regulations and the other public statements that we've seen, that there are probably multiple drivers behind this, but the main one is really the proliferation of the digital services taxes or other measures that employ source-based principles. And it, as I mentioned, it precludes the creditability of foreign tax unless the applicable tax law does employ nexus principles that would satisfy what is in these new regulatory requirements. And the requirements do distinguish between a U.S. taxpayer that is taxed as a resident of the foreign taxing jurisdiction versus a non-resident of the foreign taxing jurisdiction. And for a tax that's levied on a resident of on a taxpayer that is a resident of a foreign jurisdiction, that tax will only satisfy the attribution requirement if the taxing jurisdiction's transfer pricing rules apply arm's length principles and don't take into account as a significant factor the location of customers, users, or other destination-based criteria. You do, as just an offhand thought, you now, I suppose, do need to worry that if you have a situation where a taxpayer is subject to a residence-based tax in a jurisdiction whose transfer pricing principles aren't really aligned with current OECD practices, whether there's a risk of non-creditability. Brazil, I think, comes to mind in that situation. For non-residents, a tax needs to satisfy one of three rules: an activity-based attribution standard, a source-based standard, or a property situs-based standard. And to satisfy the activities-based attribution standard, the tax base of the foreign tax needs to be limited to gross receipts and costs that are attributable to the taxpayer's activities in the jurisdiction under quote unquote reasonable principles. And the regulations do indicate that principles analogous to the U.S. effectively connected income or ECI rules would be considered reasonable. And they specifically call out that a tax using destination-based criteria or deeming the existence of a trade or business or otherwise creating a permanent establishment based on the activities of another person that's not an agent of the taxpayer or a pass-through entity of which the taxpayer is an owner would fail this standard. And I think the last part, I'm speculating a bit, but I think that's meant to sort of pick up diverted profits taxes that exist in jurisdictions like the UK and Australia. So to satisfy the source-based attribution rule, which may be the one that's of most immediate concern to most taxpayers, the tax base has to be limited to gross income arising from sources within the taxing jurisdiction, determined, importantly, using source rules that are reasonably similar to the U.S. federal source rules. And the regulations specifically indicate that for services, that means a payment's got to be based on where the services are performed. And for royalties, that means that the payment's got to be based on where the IP is used or where the right to use it exists. For property, the source-based attribution rule basically kicks you to the activities-based and property situs-based rules to say this requirement is satisfied with respect to the sale of property unless it can satisfy either of the other two standards, put another way. Property-based attribution is satisfied for real property if a foreign jurisdiction is using something analogous to our FERPTA rules. So if it's a sale of dirt and sticks real estate or a sale of a company that has a substantial amount of its value attributable to local real property holdings, then that avenue might exist to satisfy the size-based attribution rule. For other property, taxing jurisdiction needs to apply rules similar, again, to the US UCI rules. So, in other words, ought not to be taxable unless the income is somehow connected to a trade or business that's carried on in that jurisdiction. All significant changes, I think, in the eyes of the tax community. So with that, let me toggle over and talk about the in lieu of taxes under Section 903 and what's happening with that, because there have been significant changes made to those rules as well. Under the prior rules, levy was considered to be in lieu of tax if it was a tax within the meaning of the 901 rules, which we discussed. And it satisfied a substitution requirement, which meant that it was imposed in substitution for and not in addition to an income tax levied by that same jurisdiction. It was immaterial whether the tax itself was a net income tax or a gross basis tax. And those rules were generally believed to permit the creditability of many common withholding taxes levied by foreign jurisdictions, including royalty withholding taxes or taxes imposed in some cases on provisions of services by non-residents. So the final regulations substantially modify the substitution requirement. And now, in order to satisfy that requirement, under this new framework, a tax either has got to be a covered withholding tax, which we'll talk about what that means in a moment, or it's got to satisfy this alternative series of requirements, namely, the foreign jurisdiction imposing the tax has to also have a generally imposed net income tax. The net income tax can't apply to the same income as the tested in lieu of tax. It needs to be established that the tested in lieu of tax but for that tax, the generally imposed net income tax would apply to the income that's actually subject to that levy. And lastly, that the generally imposed net income tax, hypothetically, if it were applied instead of the in lieu of tax, would satisfy the attribution requirement that we just talked about. And it's worth pausing for a second on the third and fourth requirements there, because I think on the third one, that may be harder to satisfy in some cases, or to reach your requisite comfort level, whatever that may be, in some cases, depending upon availability of information in the taxing jurisdiction. The regulations do explain that this needs to be established based on a review of the foreign country's tax law or legislative history, and they do also helpfully provide that if the net income tax and the in lieu of tax were enacted contemporaneously, that can help to establish that requirement 3 is satisfied. But it is new, and it does seem like in some circumstances it may be practically difficult to navigate. And obviously, item 4 is a big deal because they're importing the attribution requirement into 903. A covered withholding tax, the requirements there are similar. It's a covered withholding tax, very high level, is a gross basis tax that's imposed on non-residents. where the foreign jurisdiction imposing the tax also applies a generally imposed net income tax, which satisfies a non-duplication standard similar to what we discussed above. In other words, the tested in lieu of tax isn't imposed on the same income as the net income tax of general application. And the withholding tax satisfies the source-based attribution standard that we discussed above in the context of the 901 rules. And that's actually also worth a moment of time, because when you look at 903 regulations, and in particular the examples 3 and 4 in 901-1D, you come away with the impression that there are certain existing withholding taxes that may no longer be creditable for U.S. federal income tax purposes under these rules. And the prime example where I've seen the most concern is around a foreign withholding tax on royalties, which under the laws of the foreign country is imposed because on the basis that the royalty payment was made by a resident of that country to a non-resident, rather than based on where the IP was actually used or where the rights to use the IP actually exist. And that's even if the intangibles are used solely in that jurisdiction, based on the examples in the regs, it seems that tax still wouldn't be creditable. So where does that leave us? I think, it leaves us in a spot where there's some immediate issues around creditability of existing withholding taxes. And I think there's been some discourse on this, and Treasury has expressed some inclination to go back and revisit this. I'm not expecting that there would be a wholesale change in the approach to the attribution rules, or a directional change in the way that the new in lieu of rules work. And I think one possibility that I've heard is that they might develop a safe harbor system. So for instance, in the context of that royalty tax, if you could establish that in fact the royalty was in payment for the use of IP solely within that jurisdiction, or rights to use the IP solely within that jurisdiction, then you might be able to obtain a credit, even though the foreign law doesn't comport with the U.S. attribution rules. So we don't know where that will land, and that's a space to watch. But I do think that wherever that comes out, it's unlikely that the change would be substantial enough so that what we've talked about as digital service taxes would be likely to become credible. Or, to Tim's point earlier, part of the one of the important features of Pillar 1 Amount A is that to the extent that taxable income or taxing right is allocated to a particular jurisdiction, somebody else needs to cede that. And if these are the rules that we're working with when Pillar 1 comes into effect, the answer is that there wouldn't seem to be a way to credit that here in the U.S. And Tim and Bill, maybe that is a good segue back over into the pillars. So I'm going to take a shot at unsharing this and hand it back over to you.
I think, well, just a comment on that. I guess our problem here with the new regs, foreign tax credit regs, would be double taxation, obviously, with the Amount A. I think that's the kind of interaction, if you will, that we're talking about. Maybe Tim, you want to pick up on pillar 2?
Absolutely. So let me share my screen again. You should see it now, right? Perfect. Then let's jump to pillar 2. As I said earlier, the objective of pillar 2 is that multinationals shall be subject to a minimum level of tax for all profits generated all over the group in any jurisdiction. And if you look at the very first publication on these rules of the OECD, the background of this objective is that they said they wanted to protect the developing countries, because up to now, developing countries have a motivation to offer low tax rates to attract investors, although these tax incentives have been found to be ineffective. And now, by introducing a global minimum tax, these countries gain a new freedom. They are now free to aim for higher tax rates, and because the tax rates are taken out of the equation. The reality is, at least in my opinion, that's just nonsense. Nobody cares about the developing countries. They are now forced to increase their tax rates because the tax is levied in another country anyway, which will, of course, result in a shift of investments. Investors will shift their money to countries with better infrastructure, with political stability, with higher skilled workforce, and so on, if you take the tax credits out of the equation. If you look at the publication and the paper that is cited as a kind of proof for that claim, and you have some experience with empirical research, you will find that it's not really a good paper. It was conducted in Africa in the very early 2000s, and it was just a survey of managers. So not really a good job, but that's the background of these rules. So the solution to get to this minimum level of taxation is that a top-up tax mechanism is introduced to make sure that every single dollar is subject to this effective tax of 15%. And of course, the US GILTI rules played a role here as well. They are kind of the role model for these Pillar 2 rules, because the GILTI rules have been the first kind of CFC rules that actually tax active income and not only passive income. And the OECD has taken over that idea. The timeline is the same as for Pillar 1, so the rules shall enter into force in 2024. And the joint statement that I mentioned earlier also applies to Pillar 2. So no matter whether the US will join this idea, and no matter whether Hungary is giving up its opposition, Germany, France, Spain, Italy, and the Netherlands want to implement these rules in the given time frame. So let's talk a little bit about the scope. Not everything, you don't need to remember everything that is written on this slide. However, you should remember that the critical threshold is 750 million euro in group revenue. So if you are a group and an M&E group, and you have revenue exceeding that threshold, you're in the scope of the Pillar 2 rules. What is an M&E group? An M&E group is not only a group with many subsidiaries in different locations, in different countries. It could also be a US entity that only provides for a permanent establishment abroad. That does also qualify as an M&E group. And talking about these numbers, so the revenues and the amount of tax that is paid and the income and everything, talking about these numbers, they are always based on the consolidated financial statements of the so-called UPE, the ultimate parent entity of the group. So no matter whether these are US GAAP consolidated financial statements or IFRS or German local GAAP. This is the gap that is relevant for all the numbers that are relevant for calculating the Pillar 2 rules. In the interest of time, we can jump over some of the not so relevant things. Maybe you want to remember the last point. There's a de minimis exception for entities with domestic revenue that fall short of 10 million euro and profits that fall short of 1 million in a 3-year period. So what should you do if you are in the scope of the Pillar 2 rules? Then you need to apply the primary rule and the secondary rule or backstop rule. The primary rule is the so-called income inclusion rule. And this income inclusion rule imposes a top-up tax for the low tax profits of subsidiaries at a higher level, at the level of the ultimate parent entity or of an intermediate parent entity. We come to that on the next slide. Because the order with regard to the competency to levy the top-up tax is allocated following a so-called top-down approach. If low tax income of subsidiaries or group entities is not taxed under the income inclusion rule, then the secondary rule, the backstop rule, kicks in, which is labeled as the under-taxed payment rule. And this rule will make sure that actually all profits are subject to the minimum tax. So let's look at a brief example and talk about the basic rules that are laid down in the income inclusion rules. The basic rule 1 says the ultimate parent entity, the UPE, pays a top-up tax for all low tax income of its direct and indirect subsidiaries. So ACO would be entitled, in this example, ACO would be forced or entitled to tax the low tax income of SECO in this picture. Then basic rule 2 says every intermediate parent entity, so every IPE, is also entitled to collect the top-up tax for low tax income of its direct and indirect subsidiaries. To prevent double taxation, basic rule 3 says if a qualified income inclusion rule has to be applied at the level, at a higher level, and the IPE would not be allowed to collect the tax. So looking at our example, ACO is resident in a country that does not provide for a qualified income inclusion rule. Could be the US in this picture because the GILTI provisions do not constitute qualified income inclusion rules. Then BICO and BICO2 in this example would be entitled to actually collect the tax because there's no qualified income inclusion rule at a higher level. I think in the interest of time, we can skip basic rule 4 and 5. They are dealing with partially owned parent entities. So you can see that there's a lot of complexity that is added if we do not speak about 100% shareholdings, but third-party shareholdings that exceed 20%. Then we talk about POPs, partially owned parent entities. But we're skipping that in the interest of time. Maybe basic rule 6 is an important one because there's an interesting difference with regard to the EU proposal of Pillar 2. Basic rule 6 says provides for a same country exemption. That means that the income inclusion rule is not applied for profits from subsidiaries of the own country of residence. So if there was a subsidiary of BICO1 in country B that was low tax, this low tax income would not be subject to the income inclusion rule at the level of BICO1. Same country exemption. So let's talk a little bit about the mechanics in more detail with regard to the income inclusion rule first. The competence to actually collect the top-up tax under the income inclusion rule is allocated in 2 steps. In the first step, the total amount of top-up tax for the whole group of each entity is determined using the formulas that are depicted on the slide. So if you try to explain these formulas, the top-up tax is equal to the tax rate difference, so between the minimum tax rate and the actual effective tax rate, times the excess profit. And the excess profit is, again, the low B income, the low tax income in that specific jurisdiction, minus substance-based income inclusion. And if you look at the second line, so how the substance-based exclusion is calculated, this might remind you of the Green Book proposal of Mr. Biden, because that was actually the intended change for the GILTI rules. So the substance-based exclusion is calculated as 5% of the carrying value of eligible tangible assets, QBAI maybe in US fashion, plus eligible payroll costs. In the second step, the total amount of top-up tax for an entity is allocated among its direct and indirect shareholders based on the inclusion ratio. And to say this in a simplified way, it's not exactly this way, but almost this way. The inclusion amount is equal to the global income of a low tax entity times the shareholding percentage. So if I'm holding a 30% stake in a subsidiary and I'm entitled to levy top-up tax, then I would be entitled to levy 30% of the top-up tax that is due for that entity. Then talking about the secondary rule and its mechanics, so the UTPR, this is super relevant for US entities or for US multinationals, because even if the US do decide to not introduce rules that are in line with Pillar 2, and they do not levy taxes according to a qualified income inclusion rule, all other entities of the groups would be entitled to collect the top-up tax by applying this under tax payment. So a German entity might be entitled to collect the top-up tax for a French sister company or for a Lux holding company above it. And the mechanism, how this is performed, is pretty similar to what was intended with the SHIELD rules in the Green Book of Mr. Biden. So the top-up tax would be collected via denying deduction at the level of an entitled entity. The entities shall be denied a deduction in an amount resulting in their required tax amount that is necessary to lift the tax amount for the low taxed entity's income to the minimum threshold of 15%. So if I have expenses of 100 and to meet this 50% threshold, 30% of the 100 should not be deductible, then this is actually done via the basic rule. As an exemption to avoid double taxation, the top-up tax is not collected under the under tax payment rule if the respective income has already been included at a higher level in course of the income inclusion rule. The competence to actually collect the top-up tax under the under tax payment rule is again allocated in 2 steps. In the first step, for each entity of the group, the total amount of top-up tax is calculated, and in the second step, the right to tax, the right to actually levy that top-up tax is allocated among the other group entities via the formula shown. So it's 50% of the right is allocated according to the employees, so the number of employees in their jurisdictions, divided by the number of employees in all UTPR jurisdictions, and 50% of the right is allocated according to the value of the tangible assets, so total value of tangible assets in the respective jurisdiction, divided by the total value of tangible assets in all jurisdictions that are actually entitled to levy this this top-up tax under the UTPR. To maybe as closing remark, some related developments within the EU. The European Commission has already issued a proposal for a directive implementing the Pillar 2 model rules. This directive needs to be implemented into local law, into domestic law. So France has to introduce it into French law, Germany has to implement it into German law, and so on. And of course, there will be differences in the implementation of this that will create interesting interactions with regard to double taxation. That is the first thing. The EU directive does, interestingly, not provide for the same country exemption, so the basic rule 6. So that means if there's a German entity having a German subsidiary or a German PE that is actually low taxed, then the income inclusion rule or the UTPR would actually be applied in Germany. Yeah, also more domestic cases are covered by the income inclusion rule, and I think that's clear from that. And I think it's important for you as advisors of US multinationals to understand that there will be a lot of different filing obligations for the subsidiaries of your US groups. So if they're in the scope of these rules, no matter if the US introduce a qualifying income inclusion rule or not, there will be filing obligations that might differ between the European states based on that directive. So the filing requirements in France might look different than in Italy, might look different than in Germany. So you definitely have to make sure that you go through the definitions, identify your entities, and the respective filing obligations. Last comment, that's the last bullet point here. The EU is currently looking into introducing a new subject to tax rule along the Pillar 1 deliberations. And the subject to tax rule shall be an amendment of the so-called interest and royalty directive. And treaty benefits, so the 0% withholding tax rate, shall only be granted if the corresponding income is actually subject to minimum taxation abroad. That's it from my end on Pillar 2, and I think I hand over to you again, Brian and Bill.
Okay. I'm going to put up my slides, please.
One moment.
Okay, thank you. Okay, there we go.
Is that correct?
Thank you.
Okay.
Yep. Talking about is two U.S. called minimum taxes. One that was just recently enacted, a corporate alternative minimum tax, and the Gocke provisions that Tim has mentioned earlier that it's been with us since 2017 Act. Just next slide here.
Sorry, one moment. I had a problem with my PowerPoint display.
Right, that's it. Yeah, this is the formula for this new corporate alternative minimum tax. I put it in two pieces here. It's a tentative minimum tax minus a regular corporate tax plus another minimum tax that we've had in our system since the 2017 Act, so-called BEAT, the base erosion tax. The tentative minimum tax, which you can substitute in, just using standard algebra, is 15% of something called adjusted financial statement income, which is a new concept, minus a kind of foreign tax credit to avoid the kind of double tax being imposed by this 15% rate. This particular new tax has a lot of kind of mixed concepts here. As you can see, it has the regular tax, which is our regular corporate tax. It has this base erosion tax, which is this a minimum tax for basically U.S. companies that are making payments to foreign-related parties. It has this financial statement income, which is the core of the 15% tax, if you will, which is based on financial statement concepts, which is kind of foreign to our law because we use our own tax accounting concepts, which are in many cases quite different from financial statement income. And then we adjust the financial statement income to make it come kind of closer to taxable income. So it's a kind of strange set of things going on here. But that's the statute we ended up with. Go to the next slide. Who does this apply to? Well, it applies to any corporation except our so-called S corporations, regulated investment companies, and real estate investment trust entities, basically pass-through or semi-pass-through type entities that meet a so-called average annual adjusted financial statement income test. It's got 6 adjectives in front of test. It's a very awkward acronym under certain periods that I've listed there. Essentially, it becomes active in 2023 when you go through all of this, the rules that I just stated there. So the next slide. So what is this income test? Well, it's you look at this for purposes of determining whether you've got a applicable corporation, not the tax itself, not the tax base itself. You take a group which is based on the so-called single employer concept, which takes into consideration a lot of affiliated entities, which we won't deal with, where there is a for a 3-year period, either equal to or more than $1 billion of financial statement income. If it's a foreign parity group, there's one coming into the U.S. from Germany or some other country, the foreign group has to satisfy the $1 billion test that's up there, plus whatever's in the U.S. has to be $100 million or more for a 3-year period. So it cuts back what foreign parity groups would be subject to this tax, but does not eliminate it. Go to the next slide. This defines what a foreign parity group is, and we can look at that. But basically, you have to have a domestic entity and a foreign entity in the same group. If you have a foreign entity that's engaged in a U.S. trade or business, that is through a U.S. branch, and the branch is treated as a domestic corporation owned by a foreign corporation. So you create a foreign parity group, even though it's just a PE of a foreign company. Look at the next slide. This is the definition of what is the adjusted financial statement income, which is now the base of the tax is allocated to a single corporation that meets the standard of being in the group that we just described. Applicable financial statement is basically a certified statement in accordance with the general accepted accounting principles. If we don't have a situation where it's filed with our Securities Exchange Commission, then there's alternative tests that can be satisfied. But basically, it's got to be an audited financial statement that's filed with some federal group, or the next slide shows it's made in accordance with the IFRS, which is International Financial Reporting Standards, and it's filed with some agency of a foreign government, which is, quote, equivalent to our SEC. And then if you can't satisfy any of those requirements, the IRS may, the Treasury through the IRS may designate what regulatory body would satisfy this filing requirement. So that gets you to the right financial statement. And then the next slide, we have all the adjustments. You've got the financial statement income from the right set of financial statements. Then we've got a series of adjustments. I won't go through these, other than note that you pick up the so-called distributive share of financial statement income of a partnership, which is not something that we've ever done before. So that's going to take some regulatory guidance. Also, you note that towards the bottom there, depreciation deductions allowed by the Internal Revenue Code, which includes complete write-offs, are now a little less than a complete write-off, depending on what year we're in. So we're going back towards tax accounting concepts within this new concept of financial statement income. Then there's special rules for net operating losses, which is again kind of a tax concept, and it does not, these rules do not adopt tax accrual accounting concepts, but it uses really the tax concept where you've got carryovers and so on. All right, then the next slide talks about this foreign tax credit. I won't go through that, but mechanically, it's just to avoid a double tax. The 15% tax is not imposed where there's also an underlying foreign tax. So the next slide. Next, please. Here, I've tried to compare this new corporate minimum tax, alternative minimum tax, to the globe concept under Pillar 2 that Tim was talking about. I've broken into several categories here, and feel free, Tim, to comment. The scope of the under globe is this 750 euros, which is different than necessarily the $1 billion of net income or consolidated or financial statement net income. There's adjustments to financial county income under globe, but those adjustments are different if you looked at them than the ones we have for our alternative minimum taxes. I think 17 adjustments for globe, and we've got 14 or 15, depending on how you count, adjustments under the alternative minimum tax, and they're largely different. I've already talked about the covered taxes. It's, deferred accounting, unless there's a special election, is generally used under Pillar 2, which is a financial accounting concept, whereas the U.S. has this, our alternative minimum tax is kind of carryover. Next slide. An important point here, under globe, there's not a blending of rates between jurisdictions. It's a jurisdiction by jurisdiction calculation, as Tim described. Under this alternative minimum tax, there is, of course, a blending, and we'll see that you have the same issue under GILTI. their substance-based exclusion under GLOBE is different than the one that's under, well, there is a substance-based exclusion under Pillar 2, but not under the alternative minimum tax, or is under GILTI. Permanency of status under GLOBE, it seems like you can, if you fail to meet the test for enough years, you'll fall out of the GLOBE system, the Pillar 2 system. Under the alternative minimum tax, once you're in, you can only get out if there's a change of ownership, which is a defined term, or if you haven't satisfied the test for enough number of consecutive years, the Treasury may have some rules to grant you relief. But otherwise, you're kind of, once you're in our alternative minimum tax, you're kind of always in it, unless you get some special relief. Let's move to the GILTI provisions. Next slide, please. Next one. Here, I'm not.
Bill, I just want to hop in for a minute. So it's 10:25, so we're getting close to our close out time. So I'm just wondering if you're near the finish, or
I'm near the finish, don't worry.
okay, all right, great.
All right, so this is as I started to say, that I'm not explaining what GILTI is. That's an anti-deferral provision where income essentially of foreign subsidiaries owned by U.S. Corporations and individuals are picked up on a current basis with a lot of adjustments we don't have time to talk about. But what are the differences then comparing GILTI to GLOBE? Well, the target rate for GILTI is 10.5%. GLOBE, as we already know, is 15%. There are a lot of differences in how the income is calculated. Again, the GLOBE is jurisdiction by jurisdiction, whereas the GILTI aggregates results from all jurisdictions. There's reductions for losses against profits in the GILTI system. In the GLOBE system, each entity kind of stands by its own. We go to the next slide. The foreign tax credit. That we do have a foreign tax credit under the GILTI provisions. What I mentioned here on the other side here is whether the income inclusion rule or this one that undertaxed profits rule that I don't think Tim mentioned that, but that's another kind of backup rule, whether those would be creditable under our foreign tax credit rules, because they're essentially picking up taxes on income that's in another jurisdiction. So I'm not sure the attribution rules get satisfied, especially under the undertax payment, undertax profits rule, which doesn't require any necessary nexus to the income that's being subject to an additional tax. So I think you have U.S. foreign tax credit rules problems there. Then in the substance-based carve-out, in the GILTI, it's a 10% of adjusted tax basis of tangible property. It's an amount that doesn't get picked up currently in our kind of GILTI top-up tax, if you will. And in the GLOBE, it's a wider type of substance rule that Tim mentioned was in the Green Book. By the way, if you want to find out what our U.S. tax rules are, you don't go to the Green Book. You really go to Senator Manchin's website, because he seems to control, what legislation is going to be passed, at least until we have our election and there's maybe some change in the Senate configuration. And the last page here is some other ideas, which is the income inclusion rule compliant with the GLOBE system? And I'm suggesting it's not. And then is the GILTI system a qualified CFC regime? If it is, then you get to count the tax before you start computing the top-up tax amount. And then, so it's unclear whether GILTI goes there or not. And then there's another rule, which Tim didn't mention, the qualified domestic minimum top-up tax, another awkward acronym. which basically allows the low tax jurisdiction to essentially increase their own corporate tax to pick up any amount of tax that does not meet the 15% effective rate. And the question whether that would be credible for U.S. taxes, U.S. foreign tax credit purposes. It's the tax is attributable to income actually earned by the low tax jurisdiction, but it's based upon whether there's a U.S. tax imposed or not. So it may be, could be a soak-up tax, which is not then permitted as a credible tax. So I think that then finishes what I wanted to talk about. Well, there's one more page there. What has to be implemented by a treaty, and whether guilty is acceptable or not. Some in the current form, whether that would require a treaty or not, that's unclear. Treasury is asking for acceptance of the current guilty regime without amendment, principally because they don't think they can get an amendment through under the current Congress. Okay, is there any questions we should pick up?
There's one question from Sanford Millar, and it says, where will disputes be litigated? But it doesn't define which disputes. But anyway, if you have an answer to that, go ahead.
Do you want to give that a shot? Tim?
Oh, sure. Yeah, I mean, of course, these rules will definitely increase the cross-border tax disputes. And one option would be to go for a mutual agreement procedure. So relying on the respective treaty. So between the US and Germany, or Luxembourg and Germany, or wherever the dispute is. But let's see. I mean, that's still one point that is unclear. The avoidance of double taxation with regard to Pillar 1 is expected to be subject of another public consultation paper.
Okay. All right. Thanks. Okay. Well, everyone, thank you so much. This has been great. Lots of wonderful information here. So thank you for the materials. If you are interested in becoming more involved in the tax section, please come to our monthly meeting, which will be on October, I believe it's October 20th. It's the third Thursday of the month at 8:30 in the morning. We will actually be in person this month at my office, and you'll be treated to a bagel breakfast. So looking forward to seeing you there. We'll also have an option for Zooming in if that's geographically not feasible for you. And our next tax program will be on November 1st. We'll have a program on civil and criminal employment tax matters. So thanks everybody for joining us, and have a very wonderful rest of your day. Take care. Bye.